appeal in a matter of the claim on application of Quaye and the Secretary of State of Justice.
My Lady, my Lords, I appear on behalf of the Secretary of State for Justice with Ms Sullivan and my learned friends Mr Fitzgerald, King's Counsel, and Ms Woodrow appear for the respondent, Mr Quaye. Could I please start with some housekeeping, and could I confirm that the court has a core bundle running from tabs 1 through to 18, 297 pages. Secondly, a supplementary bundle, tabs 1 to 13, running to some 314 pages, and an authorities bundle with 25 authorities running to 876 pages. In addition, my Lady and my Lords, the court should also have my learned friend's reply and speaking note, together with 4 authorities filed yesterday: Peters, Dalton, Camtico, and Thunder, and that I'm sure my learned friend will refer to as and when he needs to.
How many tabs did you say the core bundle should have?
It should have 18, my lord, the addition being the supplementary skeleton filed on the 3rd of February that I hope the court has.
Did you say that there were some additional authorities?
Yes, they were sent by email yesterday by my learned friend. Peters, Dalton, Camtico, and Cunliffe.
Seem to have them.
They came my email.
I'm not planning to invite the...
My Lady, we have copies of those.
Could I have them now?
Yes.
Thank you. Don't worry, Mr Fitzgerald. I don't think they're going to be referred to imminently,
Well,
so do you want to just sort them out and
My Lady,
hand them up at a
we
convenient
will be
moment?
referring to them in due course, but I
Right, thank
don't
you.
think they're necessary now.
Thank you.
Thank
Yes.
you, my Lady. So,
Right.
as I say, and amongst that, the court should have our supplementary skeleton argument on behalf of the appellants, and I just apologise for the lateness of that document, but I hope it's
Right.
helpful. Turning then, my Lady, my Lords, to the issues on this appeal and proposed running order. This is, of course, the Secretary of State's appeal following the Divisional Court's conclusion that Section 27A, subsections 1 and 11 of the Crime Sentencing Act 1997 are incompatible with the Convention, specifically incompatible with Article 14, read together with Article 5 and Article 5 alone. It's an appeal brought with the permission of the lower court, which granted permission on the basis there was some other compelling reason for the appeal to be heard, on the grounds, first, that a declaration is, of course, a significant constitutional step, and secondly, that the availability of reviews of detention at His Majesty's pleasure and those sentences is a matter of wide public interest. When granting permission, the lower court refused, though, the respondent's additional complaints that the same provisions are incompatible with Article 6 and 7 and refused the appellant permission to appeal on those grounds. In any event, though, the respondent invites the court, if it allows the Secretary of State's appeal on Articles 14 and 5 and 5, nevertheless to uphold the declaration of incompatibility on Article 7 grounds. So, my Lady, my Lords, with all that in mind, the proposal from the bar is that I should open on behalf of the Secretary of State under grounds 1 and 2. My learned friend Ms Sullivan will then address the court on Article 7, except, of course, there's no permission yet, but it seems sensible to run through all issues once. And then, of course, it's over to my learned friend to address the court on each of those grounds, and then, of course, a reply from us. I hope that meets with the court's approval. It seems the most sensible way of...
Yes, it does.
As I've indicated already, this appeal concerns then the compatibility of Section 27A with the Convention. It was introduced by Parliament through Section 128 of the Police, Crime, Sentencing and Courts Act 2022. I know the court will appreciate the context of the issues already, and so I'll take this shortly. The relevant amendment concerns the restriction on the availability of a minimum term review in the context of a sentence of detention at His Majesty's pleasure, or DHMP. DHMP, of course, is a mandatory life sentence which must be imposed on any person convicted of murder if they were under 18 at the time of the offence. When imposing the sentence, the trial judge is required to set what used to be referred to as a tariff and is now referred to as a minimum term. And historically, one of the unique aspects of a DHMP sentence was that although the minimum term was set by a trial judge, an application could nevertheless be made for its reduction from the halfway point of that minimum term and at 2-year intervals thereafter, those processes having operated as a matter of policy. Of course, a reduction in a minimum term or tariff didn't necessarily mean that the offender is released. Of course, release is still subject to a decision by the parole board. But the effect of 27A, which is directly an issue for present purposes, is that it precludes any such application for a review of the minimum term if the offender was aged 18 or over when sentenced. There were other changes affected by sections 127 to 28 of the PC SCA 22, which I should perhaps summarise very briefly for context. Firstly, 27A also reduced the opportunities for a minimum term review for those sentenced when under 18. If under 18 at the date of sentence, offenders can still apply for a minimum term review after serving half, but can only apply for further 2-year reviews from, if still under 18, on the date of the further application. Secondly, Section 128 introduced Section 27B, which put the minimum term review process on a statutory footing with the court the sole decision maker. Before that, the court had made a recommendation which the Secretary of State for Justice accepted, and strictly therefore the challenge was to the Secretary of State. Thirdly, under Section 127, the starting points for the minimum term in DHMP cases were amended. They are now found in what is Schedule 21 of the Sentencing Code, and that replaced a single starting point of 12 years and introduced a scale of starting points determined by reference both to the offender's age and when the offence was committed. But as I say, the issue here is Section 27A and the restriction of the right to apply for a review if aged 18 when sentenced. As to the facts underlying this claim, you have the sentencing remarks of the trial judge.
Before we leave that,
I'm so sorry, Mark.
given that after 2000 the judge fixed a minimum term, you've got the non-statutory process, what was the Secretary of State actually doing on a non-statutory basis if he or she was reducing the minimum term? Or were they allowing them out earlier on licence or what?
Well,
Because the term is fixed by the judge in accordance with the Act.
yes, the role of the Secretary of State was firstly through their officials to determine whether the relevant threshold was met for the case to go before the judge. Then the judge indicated what the amended term should be, and that was then given effect to by the Secretary of State.
Yes, but how? Because the statute is provided for the fixing of the minimum term.
Yes. Well, I confess I don't have an answer to the precise operation. I can obviously find out and come up to the court on that. But that is as set out in the statement of Mr. Webster in these proceedings. But I'll find out the precise mechanism by which that
Well, it's not the mechanism, it's the lawful basis
Yes,
of it.
I accept that, of course. Turning then to the facts of the claim, as I say, you have the sentencing remarks of the trial judge, supplementary bundle, tab 8. No need to rehearse the details of what was said there, but just in terms of the operation of the legislative scheme and its implication for this appeal, the respondent was aged 17 years, 9 months when he murdered his victim, Mr. Barrett, with a knife on the 10th of May 2014. He was convicted at trial of murder, ABH, and possession of a knife on the 20th of November 14, when he was 18 years and 3 months. And on 16th of January 2015, when he was 18 years and 5 months, he was sentenced to DHMP under what was then Section 90 of the Powers of Criminal Court Sentencing Act 2000 and would now be Section 259 of the Sentencing Code. As I say, under Section 82A, the judge set the tariff or minimum term, and he did so in this case at 15 years, having regard to the respondent's age at the date of his offending, and para 7 of what was then Schedule 21 of the Criminal Justice Act 2003. As the judge observed, if the offence had been committed 3 months later, the starting point would have been 25 years. The halfway point in the respondent's tariff fell on the 15th of March 22. You'll see that in the chronology at tab 6, page 77. There's a reference in my own friend's submissions to the 12th of November 21, but we submit for the right date, though it doesn't matter for present purposes, is in fact the 15th of March 2022. Thereafter, though, on the 28th of June 22, Section 128 of the PC-SCA came into force, and of course, through that amendment, introduced Section 27A, the effect of which is that the respondent is presently precluded from seeking any review of his minimum term. Turning then, my lady, my lords, to ground one, three short points at the outset on the test under Article 14, which is very largely agreed. Firstly, of the four elements of the Article 14 test, when read with Article 5, only the fourth and final element is an issue. For the four-part test, of course, it's firstly, the circumstances must fall within the ambit of one of the rights protected by the Convention. We accept that it does here. Secondly, the relevant difference must be on the grounds of one of the characteristics listed in Article 14, including other status, and we accept age counts as other status in this context. And three, the claimant and comparator must be in analogous situations when we accept that arises here. So the fourth and final issue is whether the difference in treatment is objectively justified. As I say, that is the only issue that is Article 14 and 5 on this appeal. Secondly, the test for objective justification is not controversial. It's set out in Lord Reed's judgment in SC, paragraph 37. A difference of treatment is discriminatory if it has no objective and reasonable justification. In other words, if it does not pursue a legitimate aim, or if there's not a reasonable relationship of proportionality between the means employed and the aim sought to be realised. And we accept that that's the test that we have to meet. Thirdly, as to the width of the margin of appreciation, which I'll return, for the time being, I can indicate that on behalf of the appellant, we respectfully submit that the Divisional Court was correct to hold that a wide margin applied. See paragraph 46 of its judgment. Turning then to the substance of the Secretary of State's grounds on this appeal and some signposting, we start with four preliminary observations on the issues under Section 27A. First, the narrow scope, as we would characterise it, of the actual issue which arises. Secondly, the proper analysis of what Parliament did and did not do through Section 27A. Thirdly, the rationale for locating the bright line at the point of sentence. And fourthly, the significance of other life sentences imposed on those who commit offences as children where no minimum term is available. And I intend to take the first two together and explain where we say with respect that the Divisional Court fell into error at the outset we submit of its analysis, and then take the second two together and identify what we say are further errors of the Divisional Court's approach, before turning to the specific points on justification, which will necessitate looking at the points in the White Paper and Hansard by reference to the Supreme Court's decision in SC. And it's there, of course, that we look at the two limbs of justification relied upon, the interests of the victim families and the question of maturation beyond 18. And then finally returning briefly to the test of the margin of appreciation. So firstly, the narrow scope of the actual issue arising under Article 14. Develop that in this way. In practice, a sentence of DHMP is unique in two respects. Firstly, it's the only sentence available for murder committed as a child, whatever the age at the date of conviction and sentence. Indeed, it's the only sentence for a serious offence whose availability is defined by reference to the offender's age at the date of the offence, rather than at the date of conviction. And you can see that, we respectfully submit, in the structure of the chapters within Part 10 of what is now the Sentencing Code. We've given the reference in our supplementary skeleton, paragraph 26. But you'll see there that Chapter 2 of Part 10 concerns offenders aged under 18, that's at the date of conviction. Chapter 3, adults aged under 21 at the date of conviction, and then Chapter 4, adults aged 21 and over. And the sole exception to that approach, analysed by reference to date of conviction, is DHMP, which applies, of course, whatever the age of the offender at the date of conviction. Consistent with that, the court will also see, when looking at other life sentences, the nomenclature around it is again defined by age of conviction. So detention for life, if aged under 18 when convicted, custody for life, if 18 to 20 when convicted. Again, of course, the exception being DHMP. The second aspect of DHMP that we respectfully submit as unique is the opportunity, and in all cases pre-Section 27A, to apply for a review of the length of the minimum term imposed at the date of sentence. But of course, DHMP has its own history and legislative background, which is described in the Divisional Court's judgment, paragraph 6 to 15. But in its practical operation, those are the two aspects of DHMP properly characterised we submit as unique. The combined effect of them, though, is that the sentence of DHMP is imposed on a spectrum of offenders. That has at one end...
Could you just slow down a little bit,
So sorry.
Mr. Watson?
Sorry.
Yes, so the combined effect is what?
So the combined effect of the two features. Firstly, that it's the only sentence available for murder committed as a child, whenever the date of their sentence and conviction. And secondly, the availability of a review of the minimum term. The combined effect of those two features
Yes.
is that DHMP is imposed on a spectrum of offenders. At one end of that spectrum, there are those for whom all the protective features surrounding the sentencing of children are very obviously engaged. To take as an example, an offender aged 10 at the date of the offence and then sentenced 10 or 11 following conviction. At the other end of the spectrum, there are those for whom some aspects of what might be described as the protective features surrounding the sentencing of children are very obviously not engaged. An offender who was a child at the date of the offence, but is being sentenced as a middle-aged adult, for example, and we give in our supplementary skeleton the example of the Stephen Lawrence killers, sentenced to DHMP in their mid-30s. In their cases, my lady, my lords, of course the fact that the offence took place when they were children is highly relevant to their culpability and the setting of the minimum term. But they could have no proper claim to the additional availability of an opportunity to apply for that minimum term to be reviewed during the course of their adult life. It is strictly, we respectfully submit, unnecessary. Consistent with that and that spectrum, we respectfully submit that the issues on this appeal must start with the proposition that there could be no principled objection under Article 14 and by reference to age to Parliament legislating to remove the right to apply for a minimum term review in the cases of offenders who are sentenced as older adults. Because the thrust, of course, of the respondent's complaint under Article 14, upheld by the Divisional Court, is that he's being sentenced as a, quote, fully mature adult when he is only, quote, a young adult, still undergoing maturation and development. And those considerations, of course, don't apply to those sentenced as adults with respect to offending committed as children.
I'm not sure that that is the right question, actually. I wondered whether a different question is the right question. You've got two people who commit a murder at under 18.
Yes.
One, you allow them to show that they've made progress. The other, you don't. And why is that right?
Well, my lord,
You're not sentencing them at different times. You're simply saying, if you're under 18 at the time you commit the murder, we'll allow you to show you've changed. If we don't do that, if you actually get sentenced at 18.
I think that the difference is when you're looking to be able to, at the point at which you're looking to demonstrate that there's been a change in approach or heart since the commission of the offence. Because the distinction we would draw is that if the two offenders commit the offence at, say, age 10, and one is sentenced at age 15, then on any view of human maturation and development, there'll be matters that that individual could later say, for example, age 30, could not have been taken into account as at the date of sentence. If, by contrast, the offender aged 10 isn't convicted or sentenced until much older, say 30, then at that point in sentence, at the sentencing exercise is conducted then, that offender will be able to point to all of those matters that he or she can say have changed since the date of the offence. But the critical question is not what can they point to then, it's the availability sentencing exercise.
But that's happenstances because the sentencing has come so much later. In practical terms, it's unlikely that there would be more to show. But if you've got two people, a 17-year-old and a 17 years and 9 months, and the sentencing is when one is 18 and one is 17, you're saying to one, you would have the chance to show you've changed, but you're saying to the other, you wouldn't have the chance to show you've changed.
I accept, of course, my lord, that that's the heart of the issue, but I respectfully submit that when we're looking at whether, in principle, Parliament could legislate to amend the availability of the review to exclude certain persons from it, and to do that by reference to age, it has to be accepted in my respectful submission that at some point, let's take as an example 26, at some point there can be no claim to further maturation or development, and therefore no offender could point at the age of, say, 30 to matters that they said weren't taken sufficiently into account at the age of 26 when they were first sentenced. Accepting, of course, that at the sentencing exercise, the court will look at all of the offender's history, the circumstances in which the offence was committed and their culpability in that context as a child, but will then consider that culpability as against what has changed then, but that is always provided for in the sentencing exercise of a DHMP. The separate question is whether that sentencing exercise should, in principle, be capable of being reviewed later by a court, and whether an offender can say legitimately, well, things have changed since the date of sentence. And I accept, of course, that the heart of the issue is the 17 3/4 and the 18-year-old on the facts of this case and the way that this case is presented in terms of incompatibility. But the starting point must be, in my respectful submission, that if it were drawn at 16, you couldn't have the same claim to say, well, I was sentenced at 26, and I should now also be permitted to demonstrate what has changed in my life since I was sentenced age 26. And that is why we respectfully submit that it's a narrower issue, because we submit it's important, particularly when we get to the court's analysis and its starting point. It's important to start from the proposition that there could be no objection in Article 14 and 5 terms to there being the drawing of a line which excluded those in the Lawrence category. And certainly, we would respectfully submit age 26 onwards, because the entirety of the claimant's case, the respondent's case, is that it's about maturation and development.
I'm not so bothered
Yes.
about drawing a line. I accept that you must draw a line, and you've got different sentences for different people at different ages. My concern with Article 14 is about differential treatment. You've got two people who committed murder. They can only have one sentence imposed because they were both under 18.
Yes,
One of them, who committed a murder at 17, is allowed to show he's changed.
yes.
One of them who committed at 17, but as it happens doesn't get sentenced until the morning of his 18th birthday, can't show change. And it's whether that differential treatment will be justified.
I entirely accept that that is the issue, and that's the one that I'm going to confront. But I think I need to address first the starting point on which the divisional court proceeded in its analysis.
That you can't
Address
cut off
that.
the sentence because it's inherent in a DHMP.
That's right.
It's review at any stage.
Exactly, and I know your lordship's there already, and we submit if you can analyse it by reference to an age, a cut-off at 26, and say that's acceptable in Article 14 and 5 terms, then a starting point which suggests that this could never be permissible is, we respectfully submit, wrong.
Could you, at some point, address the question which certainly comes to my mind, which is whether, on the scenario that somebody who's sentenced when they are over the age of 18 doesn't have the opportunity to have a review, what's the distinction between the sentence that is imposed of DHMP and a mandatory minimum term as a mandatory lifer under the legislation as it applies to adults?
Yes, I will address that, but the short answer is that it is only the minimum term that distinguishes the offender.
But you can see that they are sentenced to DHMP.
Yes, and the
But what does that mean in this context, as opposed to sentencing them in a different way, as though they were an adult
yes, my
who
lady.
committed the offence?
Sorry. I accept, of course, that's the issue, and we respectfully submit that the answer is that Parliament grappled with that issue. It saw exactly what it was doing through the amendment in 27A, recognising that it was amending and legislating to change one aspect of DHMP sentences. But I'm going to get there.
Right. Well, we'll let you develop your submissions. You've been.
And I'm going to address, of course, the sharp edge of my Lord's question, because I accept that that's where we end up. But to make clear at the outset, we do respectfully submit, if the issue is framed in those terms, that 26 would be acceptable or there could be no complaint under Article 14 by reference to age, if it was set at 26, but the complaint is that it's drawn at 18, the court has to grapple, we respectfully submit, with the fact that Parliament did consider exactly that amendment up to the age of 26, and it was rejected in the process of enacting and deliberating on the legislation. And where, therefore, as we submit, I'll come to this, a margin of appreciation applies, we respectfully submit that that is exactly how that ought properly to operate here. And it would be wrong, and we respectfully submit the Divisional Court fell into this area, to substitute the court's own view of where that bright line should be drawn in circumstances where Parliament has considered that bright line and decided for itself to reject it. The second of the preliminary points, before I then turn to the judgment, is we respectfully submit that what's required is a careful analysis of what Section 27A did and did not do, or rather what Parliament did and did not do through Section 27A. Firstly, what it didn't do, Section 27A makes no change to any aspect of the sentencing exercise conducted by the trial judge or sentencing judge on a plea for those who commit murder as a child. Those who offend as children are properly treated differently from those who offend as adults. That's of course reflected in the sentencing exercise generally, and in particular when sentencing offenders to DHMP. It is an exercise that was and continues to be undertaken by reference to their age at the date of the offence, which will be a highly significant aspect of that exercise. Similarly, the quote, root and branch difference of approach between children and young people on the one hand and adults on the other, referred to in ZA, is still recognised, we respectfully submit, and implemented at the point of sentence, notwithstanding Section 27A. To the same effect, as at the point of sentence, child offenders are not being treated as cut-down versions of adult offenders, see Ahmed and others. Nor do we submit that guffaw is an issue where a defendant crosses an age threshold between the offence and the date of sentence in terms of the sentencing exercise, because the starting point is, of course, that which will likely have been received at the date of the commission of the offence. And in response to Martin and Estonia, which my learned friend has put in the bundles, of course, the defendant is a child. If the defendant is a child, then the trial process will be adapted accordingly and as Article 6 required. Similarly, of course, the welfare principle, Section 44 of the 1933 Act, also still applies. We respectfully submit that none of those matters are amended, and none of those important features of the sentencing exercise are affected in any way by Section 27A. Similarly, and to the same effect, we respectfully submit no material difference in the sentencing exercise for those subject to, or made subject to DHMP, against those subject to, for example, detention for life, or the discretionary life sentences. And we've seen that, we respectfully submit, very recently with the case of Axel Ruda Cabana, who was originally sentenced to custody for life on the 3 counts of murder on the 25th of January, but that was amended under the slip rule just last week, under the 4th of February, to DHMP, with exactly the same minimum term applied. No change, we respectfully submit, to the sentencing exercise conducted, therefore, in either of those cases. What Parliament did do, though, we respectfully submit, was to amend one feature of a sentence of DHMP, and it did expressly do so with respect to a discrete category offender, explicitly and eyes wide open, as we will come to. It removed the availability of a mechanism by which to apply for a review of the minimum term to those sentenced at 18 and over. We respectfully submit that that was open to Parliament as a matter of principle. We do submit that no ex parte sim issue arises here, because it was an explicit amendment made, and also, as we will see in due course in Hansard, Parliament recognised the implications of the amendment. And similarly, we respectfully submit there's no Morgan Grenfell issue of general words literally capable of having some startling or unreasonable consequences, such as overriding fundamental human rights. We respectfully submit that that's not an issue either. It's plain on its face what section 27(8)(a) does, and therefore what section 128, which introduced it, would do, and that was recognised and debated by Parliament. So taking those 2 points together and looking then, if we may, at the Divisional Court's decision, it's in tab 9 of our core bundle, starting on page 82. The analysis begins on page 98. Sorry. Yes, 98, paragraphs 47 to 48. See, my lady, my lords, the last 4 sentences begin, had Parliament wished to legislate, to change the basis of sentencing those who commit the offence of murder when under 18, etc. We respectfully submit that the reference to had Parliament, and I think we should probably add, as the Secretary of State suggests, was to change the basis of sentencing those who commit offence but not sentence 18, it would have done so explicitly. We respectfully submit that it wasn't the Secretary of State's case that Section 27A sought to, quote, change the basis of sentencing of those who commit murder under the age of 18, but not sentenced until after 18, which is the implicit suggestion there. Instead, it was the Secretary of State's case that the basis of sentencing remained as it was, but Parliament had explicitly removed the opportunity to apply for a minimum term review. And we submit, by casting this discussion in the terms that it did, the effect of the Divisional Court's approach was to cut off Parliament's legs before the Court even got to the question of objective justification. Because Parliament was clear, we respectfully submit, in what it was seeking to do, which was to change one aspect of the DHMP sentences with respect to one particular category of offender. Over the page at paragraph 48.
47, before we leave 47,
Yes.
some of the language there is resonant of earlier cases, which talks about it's not a sentence for life because there's no end point stipulated at the time. It's a detention at His Majesty's pleasure, i.e. for as long as His Majesty chooses.
Yes.
And that is why in the earlier cases it was saying, well, there must be a duty on the Secretary of State who advises His Majesty to keep it under review. But what has altered is not the nature of the sentence, but the operation of the sentence, because you've got, since about 2000, a minimum term fixed by reference to seriousness. And although you talk about a review of the minimum term, I'm not sure if that's appropriate shorthand to describe, for example, the circumstances under which a reduction in the minimum term can be granted. It's not reviewing the sentencing process as such. It's saying there may be criteria, exceptional development, and risk that can't be dealt with otherwise, or some other factor. So the operation of the sentence had already altered after Smith and from 2000 onwards.
Yes, my lord, I accept that, but in that I do think it's fair to describe a review of the minimum term in that that is the ultimate outcome of the process, is that the minimum term is...
It's a reduction in the minimum term. It's not a review of the minimum term. It's a reduction for certain factors.
Yes.
If you look at the language of the statute.
I accept that entirely. So there's a reduction. What's available is the potential to reduce the minimum term.
Not because you're redoing the sentencing exercise.
No, because, and particularly now under statute with the 2 particular points that are identified as the matters that are to be considered.
No, the only point is that the essential nature of sentence hasn't changed as a result of 27A. The operation of the sentence had already changed, and one further thing is altered, which is the circumstances in which a reduction in the minimum term is available.
Could be sought, yes.
Could be sought.
Yes, my lord, I agree, but I don't think that disturbs the criticism that we make of the way that the Divisional Court approached this issue. I beg your pardon, my lord, I'm
It
sorry.
reinforces the criticism,
Yes,
actually.
thank you. And then turning over the page, at the top, 48, again the suggestion is that there's been a change in the approach to sentencing, and we respectfully submit that that isn't correct. And the tenor of this is that 27A has driven a coach and horses through the approach to sentencing those who commit offences as children. And we respectfully submit that it didn't do that. But it, as I say, that on the one hand, but also on the other, back to the starting point, it fails to grapple, we respectfully submit, with the fact that there couldn't be objection under Article 14 and 5 to discriminating against those aged, on the respondent's case, 26 and over. And that itself, we respectfully submit, underlines that the criticisms at 47, at 48, made of the Secretary of State must necessarily include an overstatement, because in principle it was open, we submit, consistent with the sentences of DHMP, to amend their operation such that the reduction would only be available to those of a certain age. The nub of the issue, of course, is whether it can be justified drawing that bright line, in inverted commas, at 18 rather than at say 26. Thirdly, the rationale, so I said I'd take 2 together and then 3 and 4 together. Thirdly, the rationale for locating the bright line at the point of sentence, which was a further criticism made by the divisional court. We respectfully submit that there could be no principled objection to fixing the availability of otherwise of the right to apply for a minimum term reduction by reference to the offender's age at sentence. Indeed, we submit that's the only date rationally connected to the issue in hand. The issue is whether it can properly be said that the minimum term prescribed at the date of sentence ought subsequently to be capable of being reviewed. It is, of course, the date of sentence which most obviously separates out, we submit, the Thompson and Venables cases on the one hand, and Dobson and Norris on the other. Under this head 2, although I know it won't be an issue, there can of course be no objection to the drawing of a bright line. Generally, we have Clift at paragraph 76, which we might turn to in due course, on the acceptability of bright lines. Fourthly, we submit the divisional court failed to recognise the implications of the broader context, which is directly relevant, we submit, to the issue under ground 1, and the question is objective justification. And that is that there are no other circumstances under English law where an offender, even an offender who commits serious offences, extremely serious offences as a child, and is then sentenced as a child, enjoys the opportunity to review either the determinate term of detention or even to seek a reduction of the minimum term where a sentence of detention for life or custody for life is imposed. And we see no relevant distinction, we submit, in this context between those sentenced to a discretionary life sentence of detention for life or custody for life and the mandatory life sentence under DHMP.
Then you shouldn't have it at all, because that's the answer. If there's no difference, why are you giving it to one small subset of the group of people who are sentenced on the basis that they committed the offence under 18?
My Lord, I respectfully put it the other way around. For Article 14 and 5 purposes, the question is whether that distinction can be objectively justified. The fact, though, that it is providing for a review which otherwise doesn't exist in any other context, in my respectful submission, is an important starting point, because it can't be said against Parliament, well, you have removed from some offenders a right which is generally enjoyed across the board, and you have isolated this category. So, for example, if detention for life offenders, custody for life offenders, and DHMP offenders all enjoyed the right to review, the right to seek a reduction of their minimum term, and Parliament then legislated to say, well, we consider that the offence of murder is so serious that we are removing that opportunity for those aged 18 or over, we would respectfully submit that that would be a more difficult terrain in which to argue for objective justification. But of course, it is the opposite here. Here, there is no other circumstance in which even a child offender, even convicted of the most serious offences, other than murder itself, can seek a review of the minimum term. See again, Axel Ruda Cubana, sentenced to custody for life originally under the error made, amended under the slip rule, given the operation of section 27A, in fact, that has no impact on him, but he would, of course, because he was 18 when sentenced and 17 when he committed the offence, he would, of course, enjoy the right to seek a reduction of that minimum term if, in the absence of section 27A.
He was, as it happens, also sentenced to custody for life for, I think, the other offences.
He was, maybe. Yeah. So we submit that the default position is that no possibility of review is generally available, and ultimately, therefore, what has to be objectively justified is treating an adult, and I accept specifically a young adult, differently from a child in the terms of the availability of an application to reduce the minimum term. Taking those points together, turning to paragraph 52 of the Divisional Court's decision, we respectfully submit that it was wrong to conclude that setting the age at the date of sentence as a cut-off point for allowing the review of the minimum term is arbitrary. We do submit that that's wrong. It was and remains the only appropriate point at which a review that is, an application for a reduction is available by reference to age. We respectfully submit that age at the date of sentence was the relevant point. We would also therefore respectfully submit that the respondent is wrong to go further and suggest that it's capricious. Skeleton paragraph 33. Secondly, on paragraph 52 at the very end, but on the same theme, the last two sentences, the fact that the second offender was 18 at the date of sentence would be random and wholly unconnected with the offender's culpability. Differential treatment resulting from random events cannot be objectively justified. We respectfully submit that it isn't correct to refer there to the offender's culpability, because the issue on the availability of the minimum term review is rather as to their circumstances as at the point of sentence. We also respectfully submit that nowhere in this analysis is what we say ought to be there, which is a recognition that this is an exceptional feature of DHMP sentences, and that it is not an opportunity enjoyed in any other context. I accept, of course, that if you are, quote, creating rights, this is in terms of the convention, that are within the ambit, then of course they can't be applied in a discriminatory fashion. So I accept that it's not an answer to the discrimination test. See Clift at paragraph 50. But equally, we submit that what may be required by justification must in principle be lower if all that's being proposed is effectively parity with other offenders who commit serious offences. With those observations, my lady and my lords, we turn then to the objective justification relied on here and the High Court's approach to that question.
Before you do that,
Yes.
just because it will be relevant to your next section, I'm concerned that we remember what we're objectively justifying. Not objectively justifying how would I create a sentencing system for fixing the minimum term and making subsequent reductions. What we're justifying here, or considering justifying here, is the fact that at one date, people who committed an offence under 18 and who were sentenced for murder would be able to have that reviewed to show that they'd made exceptional progress. Parliament has decided to reduce that group so that henceforth only those who were under 18 and weren't sentenced before they reached their 18th birthday will have that right. And those people who were also 18 and who had the right will no longer have the right if they've been sentenced at the age of 18. So it's not like an objective justification for how would one do a sentencing regime. Can we have bright lines to say conviction is the key thing? The justification must be for if one group has it and you're going to take it away from part of that group, what's the justification for saying only some of you would have it now? That's
my lord, I entirely agree. And that's what I've got
you've got
to
to come to.
That's what I've got to confront. I accept that entirely. So turning then to the question of objective justification and the High Court's approach to that question. This, of course, brings us to the second series of issues before this court, and we would respectfully submit arguably the complex and perhaps even sensitive part of the piece, given that it's an inquiry into the parliamentary materials, the process by which the legislation was enacted in the terms that it was. We would respectfully submit it's not straightforward, not least because we would submit the instinctive response in the face of a difficult judgment or evaluation is to dive into the detail of the underlying material, to look for clues as to how to resolve the issue. But the tenor of SC we submit is that what's required here is restraint, and the collective thrust of the principles in SC that we're going to turn to are that what's required here is restraint and deference. And under this head, we would identify two questions. Firstly, what can be looked at? And secondly, how is that material to be approached? And could I ask the court please to turn to SC, which is in our authorities bundle, tab 14. It starts on page 507. This was an Article 14 challenge to amendments made to the Tax Credits Act 2002, introduced by Section 13 of the Welfare Reform and Work Act 2016. The result was that a family making a new claim for child tax credit would not be awarded the credit if they were already receiving child tax credit for 2 or more children, so the so-called two-child limit. The discrimination challenge was on the grounds that the two-child limit discriminated against adult claimants as women compared to men, and against child claimants compared to either adults and or other children who are unaffected by that limit. Notwithstanding those different facts, there were at least two shared features with these proceedings. Firstly, it's an Article 14 challenge brought against legislative amendments, and therefore considers the proper approach in that context. And secondly, consideration given to the relevance of what might be termed parliamentary materials. If I could ask the court to turn it up, please, on page 570, is the beginning of the analysis of Lord Reid, paragraph 163. Lord Reid begins with two fundamental constitutional principles that identified at the outset. This is paragraph 163 and following. First, the general warning at 165 about the constitutional impropriety of courts exercising a supervisory jurisdiction over Parliament. No part of the function of the courts under our constitution to exercise that jurisdiction over such internal procedures. Paragraph 166, second, that the government, of course, is separate from Parliament, and therefore it's the intention of Parliament that defines the policy and objects of its enactment rather than the reasons the government might give. That taken, of course, from Wilson and First County Trust number 2. And secondly, paragraphs 167 to 168, two other aspects. First, the will of Parliament finds expression solely in the legislation which it enacts. Parliament doesn't give reasons, it simply votes on a motion to approve a proposed legislative text. And secondly, decisions, this is paragraph 168, decisions taken by Parliament are not necessarily capable, in any event, of being rationalised. It is a debate in chamber. Now, I know the court will return to review Lord Reid's speech, but on the back of that, we respectfully submit as to what can be looked at. 3 materials. Firstly, the statute itself, of course, the primary guide to Parliament's intention. Secondly, the white paper, and thirdly, Hansard. The statute, of course, I don't think requires any further elaboration, but on the white paper, the proper approach there is we submit at paragraph 174, and this is in the context, of course, of discrimination claims under Article 14. And it begins, the legislation must, of course, also satisfy a proportionality test, must decide whether the means used by the legislation to achieve its policy was appropriate and not disproportionate. For those purposes, reference could be made to parliamentary debates and other parliamentary materials. And then, rehearsing Lord Nichols in Wilson, paragraph 63 to 64, and we respectfully invite the court to note this aspect of it, when the court is making this value judgment, the facts will often speak for themselves. Sometimes the court may need additional background information tending to show, for instance, the likely impact of the statutory measure and why the course adopted by the legislature is or is not appropriate. The court, and then the last two sentences, the court may need enlightenment on the nature and extent of the social problem, the so-called mischief, at which the legislation is aimed. This may throw light on the rationale underlying the legislation. And then 64, this additional background material may be found in published documents such as a government white paper, if relevant information is provided by a minister or indeed any other members of either house in the course of debate on the bill. The courts must also be able to take this into account. So we respectfully submit that we are in that territory, and specifically with respect to the white paper. Thirdly, though, and moving on into even more hallowed ground, perhaps the only hallowed ground before the court, the actual deliberations in Parliament. That's considered by Lord Reid at paragraph 175 onwards. It runs through 175 through until 184, but we invite the court to focus on 180 to 184 on page 575. Because, of course, the court has to recognise the limits of its role in this area. And at 183, Lord Reid explains that the focus, what the focus of the inquiry should be. So 183, two caveats, having established that it's court can look at such debates. First, the courts should go no further than ascertaining whether matters relevant to compatibility were raised during the legislative process, if they're to avoid assessing the adequacy or cogency of Parliament's consideration of them, contrary to Lord Nichols. The distinction between determining whether, as a question of historical fact, an issue was before Parliament on the one hand, and determining the cogency of Parliament's evaluation of the issue on the other, is real and must be respected. Skipping to the end, trawling through debate should not therefore be necessary and is unlikely to be appropriate. A high-level review of whether a topic was raised before Parliament, whether in debate or otherwise, should suffice. And then 184, secondly, the courts must not treat the absence of poverty of debate in Parliament as a reason supporting a finding of incompatibility. And noting in practice, cases of the present kind, so the Article 14 challenge, generally raise issues which were at the forefront of debate, as they were in the present case. So with those in mind, and accepting properly, we submit that that is the approach to be taken to the materials. Start, if we may, with the white paper, which is in the supplementary bundle.
Start with the Act.
Beg your pardon?
You want to start
Well,
with the Act to find out what it says?
I didn't think that it was, I did say that I didn't think it was necessary to go there, but of course we can.
Well, I just wonder whether it isn't a good idea just to
Of
look,
course.
not at the Act itself first, but to look at the bits about minimum term in the Sentencing Act 2020 to see how that is done.
Yes.
And then to remind ourselves of what happened with the amendment.
Certainly.
Just because I haven't misunderstood what happens when you fix the minimum term for DHMP.
So, does your Lordship want to go to the Sentencing Act?
Yes, just to remind ourselves what happens when a judge fixes a minimum term, so we can measure then what a judge does when he or she makes a minimum term reduction order,
Yes.
to see the extent to which it is covering the same territory or not. That may throw light on why it is you're only going to allow inverted commas changes for a certain group and not another group.
Yes. So, 258. Sorry. 259.
Yeah.
Is the obligation to sentence to a minimum term. To detention for life.
Where do
Detention.
you want us to look?
I'm following my Lord's
Well.
lead, but 259.
Where do we find that?
Sorry, is on page 57
you.
behind tab 2 of the authorities bundle.
It's not for life, it's detained during Her Majesty's pleasure.
DHMP, sorry. DHMP 258.
And the 324 defines it as a life sentence
Yes.
for the purposes of this act.
And the 324B.
And then you look at 322, and that tells you how you fix the minimum term for a life sentence, which includes detention at Her Majesty's pleasure. So we know what the court is doing when it fixes a minimum term.
Yes, and having regard, number 3, to the principles set out in Schedule 21.
Yes, the seriousness of the offence and various other matters, and in determining seriousness, you've got to look at the general principles set out in Schedule 21, and that, of course, is sentencing at age, at date of commission for murder, and then you've got to look at the sentencing guidelines, which also tell you what to do with people under 18.
That's right.
So we know that this is all to do with seriousness, having regard to chronological age and other matters.
Yes. Yes.
Clive.
Yeah.
Yeah, then you can go next. That's all you need to do now. Yeah. Now you can go to the new act.
And then, so that's the background.
Yeah.
And then I think the easiest place to locate it is within section 128, which is tab 1, page 7. And 27B, which is the relevant power my Lord's drawing attention to on page 9. And in particular 27B4, in deciding whether to make a reduction order, the court must, quote, in particular, take into account any evidence that the relevant young offender's rehabilitation has been exceptional, that the continued detention for the remainder is likely to give rise to a serious risk to the welfare and continued rehabilitation of the offender, which cannot be eliminated or mitigated to a significant degree. And the short point that I was going to make is under 27A, that it is clear on its face as to what it is intending to do and what its effect will be, as we will see when we look at Hansard, as was clear to Parliament when it debated the provision.
So now you're going to take us to the white paper.
I was, my lady. So that is in our supplementary bundle. It begins on page 103. The relevant paragraphs, sections, are on page 199. Paragraphs 3 to 8 and following. And we respectfully submit that the quote mischief, if we're looking for mischief.
Give me a moment.
Sorry. Page 199,
Thank you. And which paragraph do you want to look at?
page 3 to 8, please.
Paragraph 3 to 8. Thank you.
So the existence of the review is an important part of ensuring tariff remains appropriate as children change and develop as they mature. It's also clear, and this we respectfully submit as the mischief identified, the existence of the review procedure, particularly the opportunity for to continue reviews after the halfway point, can be extremely distressing for the families of victims. Families are contacted every time an offender applies for review and are given the opportunity to provide a new victim personal statement, a process which in many cases causes them to relive the circumstances of the crime and feel as though they have to advocate again for justice for their loved one. We submit that that is the mischief identified in the white paper. It relates to the understandable impact that a review process can have on the families of victims. And the second aspect, and I'll come in due course as to how we say this runs under Article 14, is going to the justification of age 18 as the bright line. And that is at 329. And the reference there to the fact that adults do not go through the same accelerated development and maturation that children do. I need to explain one point, but I know the court will be alive to already under paragraph 329, which is explained in the evidence from the appellant. 329, at the time that the white paper was issued, was wrong to suggest that offenders who are given life sentence for murder committed over the age 18, but who are not sentenced until they're over 18, are not entitled to reviews. That wasn't the policy position at the time when this was operating as a matter of policy. It was, though, subsequently addressed, and before Parliament came to consider the provision. So by the time Parliament looked at this, it was an accurate statement of the law. Oh, sorry, it was an accurate statement of the policy. My respectful submission will be that nothing turns on it because, in fact, as we see when Parliament looked at it, the assumption was that that was not the way the scheme was operating. The assumption was that all those sentenced to DHMP, whatever their age, were entitled, as at that date, to a review to apply for a reduction of the minimum term, subject only to 27A. So Parliament approached the issue on the basis that if you were sentenced over 18 to a DHMP sentence, you did enjoy a right to seek that reduction.
What then from the white paper is the justification? It's not the fact that they don't get it already. So we are in a situation where you're taking it away from people because of the distress on the families. And where does that explain that you take it away if they've reached 18 at sentencing, but not if they haven't reached 18 at sentencing?
Well,
the distress for the families would be the same in both instances.
Yes, and the only justification that can be pointed to is the fact that it is at the bottom of 321, adults do not go through the same accelerated development and maturation that children do.
That's to reflect the wrong view that they weren't getting them at over 18 when they were getting them over 18.
Yes, but right or wrong, in my respect.
Right back, wrong connection, okay.
Yes, does it matter when we get to Parliament's consideration of this issue? Because that is the basis upon which the bright line at 18 was being proposed. And that's the issue that Parliament grappled with, which we'll see when we look at Hansard. And we respectfully submit that that is all that can be taken from the white paper in terms of looking for mischief, and as an aspect of that, the further justification as to the bright line. And there are, of course, a series of other Secretary of State materials. They were provided to give a candid account from the department as to the background to the legislation, and in particular to address the change in policy that's underlay paragraph 329. But those are the only points we respectfully submit the court can take from the white paper. Turn then to Hansard.
Anything we need to look at from 330?
Well, my letterhead says yes. We submit that is this is not relevant to the issues here. It's dealing with a separate and different question. It's to those sentenced to DHMP as children, as the first line suggests, and since turned 18 in custody. So we don't submit that that's speaking directly to the points that we have to contend with here.
If we want to understand for the sake, it becomes clear they're talking about removing reviews after 18 because they think that people after 18 or sentenced after 18 don't have them anyway. So that's why they're focusing on that. But that does leave the big hole as to why you are protecting families when they're sentenced at 18 but not under 18. And you say, well, that's because even though they thought it had already been done, the basic fact is you've got a balance on the one hand, you don't want to affect young children who are maturing, but on the other hand, you don't want to subject families to the distress of the review.
That's right.
That's what you say it is.
Exactly.
So in a perfect world, you say you just removed everything, but you've got to recognise that those under 18 have interests too, so you say it's a balancing.
Yes, and it's ultimately where you draw that bright line. And on that, my lords, we would turn to Hansard, which is in the same bundle, tab 13.
Yes.
The question we submit is whether Parliament can be taken to have made its own judgment on the issues which are relevant to the court's assessment. And if so, the court will be more inclined to accept Parliament's decision out of respect for democratic decision-making on questions of political controversy, and that's SC paragraph 180. And consistent with that, as we've already looked at in SC, court should go no further than ascertaining whether matters relevant to compatibility were raised during the legislative process, this paragraph 183, and of course the distinction between a question of fact as to whether it was before them, as opposed to determining the cogency of Parliament's evaluation of that issue. So on Hansard, and in accordance with that approach, we respectfully submit that the following is clear, and all of these are matters going to the question of compatibility. Firstly, we start on page 310, which is the consideration of the relevant amendment by Mr. Cunningham. Firstly, Parliament expressly considered an amendment which would have raised the age at which 27A would apply from 18 to 26 and rejected it. That's the nature of the amendment being proposed at the top of 310. Secondly, Parliament recognised that the precise point in issue, namely that one of the effects of section 27A was that those sentenced of 18 would no longer be entitled to reviews of their sentence. That's also on page 310. You see the effect of the clause is twofold. First, those who have reached the age of 18 at the time of sentencing will no longer be entitled to a review of their sentence. So, grappling, we respectfully submit with precisely the issue that this court is being asked to consider, and the lower court was under Article 14, and regardless of whatever the policy position was at the time. Thirdly, Parliament recognised that the mischief or intention was to spare families of victims the trauma of having to revisit events, the significance of which it also recognised. That's in their white paper. The government set out the intention behind clause 104 as it was then, was to spare victim families, etc. Fourthly, Parliament recognised the concern that was raised that those who commit offences as children should be treated as children. That is, in the paragraph, the opposition's first major concern with clause 104 is. Fifthly, Parliament recognised the implications of the court backlog on delays to sentencing, which might therefore have an impact. No charge put into disadvantage by turning 18 before being sentenced, especially if delays caused by court backlog. Sixthly, on page 311, Parliament considered the implications of the amendment on Lord Bingham's observations in Smith and the broader case law surrounding DHMP. That's under the concept being of basing minimum term reviews, etc. Citing Smith, 2 paragraphs there.
Yeah, and where do you find that?
Sorry, that's on page 311.
Yes.
The concept of being of basing minimum term reviews on age of sentencing rather than age of time crime was committed
Yes.
has been rejected by the courts as contrary to the purpose and rationale of the sentence of detention of His Majesty's pleasure, Her Majesty's pleasure, as the great Lord Bingham set out in the case of Smith. And then 2 key paragraphs there. 7, Parliament recognised the effect of the bright line cut-off, which it describes as the cliff edge. That's just above what I have as the second hole punch. The opposition's second concern with clause 104 is the cliff edge. And also, Parliament recognised the ongoing development and maturation beyond the age of 18. Within the same paragraph, it's now widely recognised young adults are still developing their decision-making and impulse control skills well into their mid-20s. And indeed, referencing the Sentencing Academy as well, which we respectfully submit got to the nub of the issue. So this is the bottom of page 311. The concern is shared by the Sentencing Academy, which points out the accompanying fact sheet justifies removal of reviews from those aged 18 by the time of sentencing on the grounds that this is because their age and maturity will have been taken into the account at their sentencing. However, it's an accepted feature of sentencing law that the passing of an offender's 18th birthday is not a cliff edge in terms of their emotional and developmental maturity. And then over the page on 9, again confirming that the implications of 27A were such as to remove the right to seek a reduction of the minimum term at 17 to the second part of the, and of course the amendment being to change that to 26, the second half of that sentence, which begins, although we sympathise with the stated goal. The mechanics of the amendment are simple. Instead of ending the right to a sentence review at the age of 18, the amendment would make provision for minimum term reviews up to the age of 26, reflecting the widely held view that young adults are still developing in maturity well into their 30s, while also providing a powerful incentive to motivate young offenders to reform and rehabilitate. There is then a response, pages 312 to 313 from the Parliamentary Under Secretary for the Home Department, which focused on the repeated review point and didn't engage directly with the removal of the removal of the right to apply for a reduction from those sentenced at 18. But the point that was referred to, well, Mr. Cunningham, this is on page 313.
I know we're not supposed to look at whether it's right or wrong, but just to make sure that I understand what Mr. Philip is discussing, rather than whether it's right or wrong. He says
he's discussing the
maturity would have been taken into account when the child is sentenced or the 18-year-old is sentenced. There's an acceptance that further maturing may occur. There can still be a single review once the individual is over 18, obviously only if it applies to those under 18. So any subsequent reviews. Is the Minister seeking to address the question of those who do lose it or not? Or is he just dealing with the effects there on the under 18s?
I think he's dealing there with the effects on the under 18s. And that is, as I read the response from Mr. Cunningham, how it is understood.
So that doesn't tell us what the response is for the over 18s or the 18s at date of sentencing?
No, my lord, it doesn't, well, it shows that that issue wasn't engaged with, but Parliament recognised that that was the implication of this provision.
Was returned to by Mr. Cunningham,
That's right.
313.
And that was the final point I was going to take from this document from Hansard. Doesn't accept the Minister's argument, talks about the small number of applications, but he goes on to quote again from the sentencing, and we have grave concern about removal of reviews from people simply because they have reached the age of 18 at the time of sentencing, particularly at a time when cases are taking so long to reach court. For that reason, I will push the amendment to a division. So we do respectfully submit that we can properly point here to Parliament's own consideration of precisely the alternative law that the claimant would invite this court ultimately and effectively to legislate for. And we say with respect to the divisional court, firstly, it was wrong to refuse to consider this material at all, paragraph 31. And having done so, of course, it failed to factor it into the mix in its review of objective justification. And so against that framework, my lady and my lords, on justification, adopting the language of legitimate aim and proportionality, we respectfully submit that the best way of synthesising the tests on justifications, and the two put here, is that the legitimate aim pursued is the protection of victims' families. and the means adopted to achieve that end are proportionate, and specifically the selection of age 18 as the bright line cutoff is proportionate, given that adults, those aged 18 and over, do not go through the same accelerated development as children do. On the first, the legitimate aim of protecting victims' families, we respectfully submit that that is, of course, an extremely powerful consideration, and one that Parliament properly took account of. Plainly, any minimum term review or an application to reduce it will engage the interests of the victim's family. And that properly was a matter that Parliament had to consider, and we do submit the lower court wrongly minimised that point by reference to the objective relevance of the family's input to the review process. The niceties of the legal relationship between their engagement in the process and the outcome is not, we respectfully submit, in issue. What is being put in the balance by Parliament, correctly we submit, is the impact subjectively felt by the victim, by the families of victims of this process, and that was recognised by Parliament as a legitimate aim to be pursued, and on that basis, and we see that in Hansard. The real question then, of course, is whether the means adopted to achieve that end are proportionate, and specifically whether the selection of 18 as the bright line cutoff is proportionate. And on that, my lord, just three, my lady and my lords, three short points. Firstly, in terms of justification and that bright line, we submit that Parliament's approach enjoys a very good start because it set the bright line at the most widely recognised date known under English law and in English society at the age of 18. That is, of course, a date which does have very significant implications, including under English criminal law. Indeed, in the broader context, then of course, while the date of the offence, date at the age of offence is highly relevant, that's not the exclusive consideration. See the sentencing principles, the guidelines, paragraph 6.2. They're cited by the Divisional Court at paragraph 23. We have them in our authorities bundle, tab 3, page 122. The point there is that the starting point for those who commit offences under 18 will be the starting point at the date of the offence. But if 18 when sentenced, then, quote, the purpose of sentencing adult offenders has to be taken into account. So there is a distinction drawn between those sentenced at 18, generally drawn between those sentenced at age 18 for offences committed under 18. That bright line exists. Secondly, the bright line falls to be considered here in a context where the criminal law and practice affords no other opportunity to seek to reduce a minimum term for any other person who commits a serious offence as a child, either in a discretionary life sentence context or of course, if sentenced to a lengthy determinate sentence of imprisonment. And thirdly, we do respectfully submit that, notwithstanding that it's accepted that maturation continues beyond 18, it was permissible for Parliament to proceed on the basis that adults do not go through the same accelerated development as children do.
So if I could, if one looks at the position of somebody who is sentenced when they're 17, the halfway point of the tariff would mean that it would be necessary, if that process was to be engaged with properly, for those reviewing it to consider maturation after 18.
Yes.
Would it not?
Yes. Yes, I accept that. Yes. And that is why the bright line, if you like, requires justification, because if it was set at 26, then it's accepted that that would be at a point
But
where maturation...
I do that in the light of the suggestion that, as it were, there's a lack of acceleration of maturation, if I can put it like that, after 18, but nonetheless the regime as it is would provide for consideration of development post-18.
Yes, it would. And,
simply because somebody's sentenced when they're under 18.
Yes, I accept that, but I accept that what's being relied upon or referred to in the white paper is the absence of that same accelerated development in adults as compared to children. And that combines with the bright line at 18 and drawing it there, accepting, of course, and this is why it's controversial and requires the justification, that maturation continues beyond the age of 18. In a sense, that's the nub of the issue. And my respectful and final submission on this point is that if the court reaches the position where it's concerned that as to whether objective justification is made out, we would respectfully put into the balance two things. They're related. Firstly, the fact that Parliament has considered the very proposition being advanced through this litigation and rejected it. And we respectfully submit, consistent with Lord Reed's approach in SC, that that is a relevant factor and a matter that requires to be treated with respect. Lord Reed also, paragraph 162, on page 570, issues a further word of caution. We respectfully submit that may be relevant here. It's just before the analysis of Hansard, etc. 162, important to bear, page 569, important to bear in mind that almost any legislation is capable of challenge under Article 14. Goes on to cite JD. Top of 570, in practice, challenges to legislation on the grounds of discrimination have become increasingly common in the United Kingdom. They're usually brought by campaign organisations which lobbied unsuccessfully against the measure when it was being considered in Parliament, and then act as solicitors for persons affected by the legislation, or otherwise support legal challenges brought in their names, etc. The favoured ground of challenge is usually Article 14, because it's so easy to establish differential treatment of some categories of person. Since the principle of proportionality confers on the courts a very broad discretionary power, and cases present a risk of undue interference by the courts in the sphere of political choices, that risk can only be avoided if the courts apply the principle in a manner which respects the boundaries between legality and the political process. And my lady and my lords, we do submit that that is a very powerful factor that has to be put into the mix. The risk of error we submit is for the court to substitute, as we say, its own view as to where the point line should be.
We wouldn't be doing that. We'd be saying that the problem is at the moment that there's differential treatment. People who are committed the offence at 18 are being treated differently. And that one group is not being given the chance to show exceptional progress, and the other group is, in circumstances when it's recognised that it could apply to both sets of groups. How Parliament chose to deal with it is for Parliament. And in fact, all we know at the moment is that the White Paper proceeded on false footing, and all we know is that Parliament rejected an amendment saying reviews up to 26. But is it any more than that? We know that Parliament didn't go for a 26 cut-off point, but we don't yet know the reasons why they've drawn the distinctions that they have.
Well, my Lord, I would respectfully submit that it goes slightly beyond, because Parliament was confronting essentially the same submission that's made here, which is drawing the bright line at 18 is not objectively capable of justification because of that ongoing period of maturation up to, say, 26, which is the basis upon which the appellant or respondent approaches this issue. Parliament considered that, because that's the precise terms of the amendment that was proposed, and rejected it. And we respectfully submit that that has to be a matter that's put in the balance.
So Parliament has taken a view, you say, on the fact that there would be continued maturation, albeit at a slower rate, for the post-18, and has decided not to make that the key point because of the impact on the families. The circumstance in which that would be of value to the people concerned is not outweighed by the impact on the families about through having to go through it. Is that the way?
Yes, my lord, and we do say that you can see that from the discussion in Hansard. This isn't a case where nobody either recognised the issue that was presented by 27A or failed to grapple with what was on each side of the balance in terms of victims' families on the other hand and offenders' interests on the other, and specifically the interests of offenders who could claim that they had enjoyed further maturation since the age of 18 that wouldn't be capable of being put before the court on an application to reduce the minimum term. All of it, we respectfully submit, was in the mix. And so that is why, and consistent with all that, we do respectfully submit that the standard of review may be highly relevant in this context, because we respectfully submit that if we are properly dealing here with a wide margin of appreciation, that this is perhaps precisely the sort of circumstance where this court has to recognise that if it is to afford a margin of appreciation, then that necessarily requires acceptance that there may be circumstances where the court itself considers that there is an issue as to objective justification, but has to recognise that Parliament has considered it, and this is a matter that is preeminently within the domain of Parliament. And we do respectfully submit that the lower court was correct to identify and at least articulate a wide margin of appreciation, although we would submit it didn't in fact apply on the facts. You have our submissions on margin, and I know that my learned friend I think will seek to suggest that it should be a narrower margin than that which was applied by the divisional court. We do submit that alongside the matters identified in the lower court, this is also properly characterised, we submit, as a second limb to the margin question and the breadth of it, as a prison and penal policy case rather than an arbitrary detention case. And we've given the references of Clift and Stott that I don't think I need to go to now, not least because we are only seeking the same approach as the divisional court applied. My lords, that's what I intend to say on ground one, unless there are any other aspects that I can assist with.
Oh, thank you very much.
Thank you. Ground two, I can obviously take this much more quickly now that we've laid out the groundwork. The divisional courts, this is on, of course, incompatibility with Article 5 alone. The divisional court's conclusion is at paragraph 59. Perhaps you just turn that up, please. It's called Bundle Tab 9, page 102. Again, taking as the starting point, page 102.
102, yes.
Taking as a starting point that section 27A did not change the essential nature of a sentence of DHMP, and that an inherent element of that sentence is a requirement of continuing review, proceeds the removal of any possibility of reduction of the minimum term via review does generate a risk of arbitrary detention sufficient to engage the protection of Article 5. And the short point we submit is that while a prisoner is serving their minimum term in the context of a sentence of DHMP, in law, no issue as to the lawfulness, still less arbitrariness, of their detention under Article 5.1 can arise. On the facts here, very briefly, the respondent was sentenced on the 16th of January 2015 to DHMP under Section 90. Under Section 82A, on the facts here, the trial judge was required to set the tariff or minimum term, which he did. No question we submit, but that detention remains lawful and cannot become arbitrary during that minimum term. There was nothing, we submit, provisional about that exercise of setting the minimum term, and it certainly wasn't expressed in those terms, nor indeed would it necessarily ever be subject to, quote, review. The reference to its subject being provisional and subject to review tends to suggest that the statute provides for a review in all cases. Of course it doesn't. It affords a prisoner only the right to apply for a review if the stringent test is met. And we submit that the Article 5 issue is resolved by two propositions. Firstly, no Article 5 issue can arise while remaining within the scope of the minimum term. And secondly, Article 5 doesn't impose any obligation to offer an opportunity to apply for a reduction of a tariff or minimum term. And as a result, in fact, in Article 5 terms, the existence of an opportunity to apply for a review under the former procedures, for those in the respondent's case, went beyond what Article 5 requires and its removal raises no Article 5 issue. That's, of course, isolating it from the discrimination claim.
In a sense, it's not unlike discretionary release for compassionate grounds. If you have cancer at the end of your sentence, you are sometimes released.
Yes.
So you can die at home, not in prison. And circumstances have changed, and therefore you're released. I know that that's release, not removing or reducing the minimum term. But here, if you go back to the words, which is why it's useful to look at them, it's things have happened since, exceptional progress, a risk has materialised, mental health or some other things. So it's not concerned with, was it the right serious level at the start? It's, has something changed so that you should, in compassion, recognise that?
Exactly, my lord. And you can't say because of the possibility that circumstances will change, and that might lead, and it would be in even more powerful terms if it was, and that might lead to release, which of course isn't the issue in fact here. You can't say because of the potential for a change in circumstances which might lead to earlier release. In any sense, the existing serving of a sentence is unlawful under Article 5 terms in that it's arbitrary.
Existing serving of the minimum term fixed by reference to seriousness, yes?
Yes. We have in the authorities, the Supreme Court in Brown, tab 10, perhaps just go there very shortly, if I may. The court may recall the somewhat tortuous background to the decision in Brown, the Supreme Court's decision in Brown. These concerned the availability of sources and courses and other mechanisms to demonstrate that there had been rehabilitation such that would enable release. And the background is set out, is rehearsed. It begins at paragraph 8 because there was something of a toing and froing between the domestic courts, the Supreme Court, and House of Lords before that, and the ECHR as to where the obligation to provide a real opportunity for rehabilitation was located, and in particular, whether it was an ancillary aspect of Article 5.1 generally, which was the position adopted by the Supreme Court, or whether, as the ECHR held, in fact it was located specifically within Article 5.1. I don't think for present purposes I need to go through the history, which begins paragraph 8 with James, then turns to Walker, Quaye, paragraph 23, and through to 31 to 36. But because all I respectfully need to do for present purposes is to see where we get to, which is paragraph 38 on page 432. And essentially the conclusion is that the relevant obligation, and that's the obligation to provide opportunities to demonstrate a reduction in dangerousness and or rehabilitation, whether that arises generally under Article 5 or specifically under Article 5.1. And the conclusion is that the Grand Chamber's approach and the ECHR's approach should be adopted by the Supreme Court. And therefore, paragraph 39 is the key finding. The European Court regards the issue of lawfulness as arising only after the tariff or punishment part of an IPP sentence has expired, although earlier measures to encourage rehabilitation will form part of the relevant circumstances. In that regard, the European Court's approach reflects the logic of locating the obligation of 5.1a. It is only after tariff has expired that any question can arise whether continued detention is arbitrary and therefore not lawful within the meaning of Article 5.1a. The Court then goes on to consider the other effects of the Supreme Court's approach of locating it generally in Article 5, but the short point that we will arm is that it is clear, we submit an orthodox under Article 5, that while within the minimum term, there can be no issue as to the lawfulness, still less arbitrariness of detention. And that is precisely the circumstance that we are in here. And secondly, of course, given that Article 5 doesn't impose any obligation to offer an opportunity to reply for a review of a reduction of a tariff or minimum term, the existence of one doesn't raise, we respectfully submit, an Article 5 issue. And the fact that some offenders have previously been able to demonstrate that there's been a change in their circumstances post-sentence, which has led to I have to characterise as a modest reduction in their minimum term, that, in principle, doesn't affect the lawfulness of their detention prior to that review process and that reduction, because, of course, it was all consistent with and ordered by, in fact, the court at the date of the original sentence. So, Lady, my lords, that I think is all that I need to say under ground 2, unless there are any other points on that.
I think my lord raised a question about the mechanism.
Yes.
I don't know whether you're going to deal with that.
I just may need time over lunch to deal with that properly. I have in my mind the answer, but I just want to check it.
All right.
I know the mechanism, it's how it's lawful.
I
Yeah,
understand.
no, it's
Exactly.
awful,
Yes. So with the court's leave, I'll look at that over lunch. And
So we're going to hear from Miss Sullivan now
That's
on
right, on
Article
Article
7. Yes, Miss Sullivan.
Thank you, my lady and my lords. My lady, my lords, the respondent in their respondent's note invite the court, if the court upholds the appellant's appeal, to then uphold the decision of the divisional court on a different basis, namely that Section 27A contravenes Article 7 of the European Convention on Human Rights. As Mr. Watson, King's Counsel, has said, that argument did not find favour before the divisional court, and permission to appeal on that ground was refused. However, we're dealing with it now compendiously, so the court has all our submissions in one. As your ladyship and your lordships will be aware, Article 7 provides that no one shall be held guilty of a criminal offence on account of an act or omission which did not constitute a criminal offence under national or international law at the time it was committed. No issue arises with that. It's the second part, that nor shall a heavier penalty be imposed than the one that was applicable at the time the criminal offence was committed, which the respondent takes issue with. The Secretary of State's submissions on this fall into 3 parts. Firstly, the legal framework in respect which governs Article 7, and in particular the division between a penalty, the autonomous convention concept of a penalty, and a measure which relates to the enforcement or execution of a penalty. Secondly, how one tells the difference between a penalty and a measure relating to enforcement or execution, so how that distinction is to be drawn. And then thirdly, we submit that applying that distinction here, it's clear that the effect of Section 27A, the removal of the opportunity to apply for review of a minimum term, is a measure which goes to the enforcement or execution of the penalty and not a penalty itself in Article 7 terms. Starting with the legal framework, that can conveniently be taken from the Supreme Court's judgment in Morgan, which is in the authorities bundle at tab 16. Morgan was a case concerned with changes to the sentencing of terrorist offenders in Northern Ireland following 2 terrorist attacks in London. Changes were introduced in England and Wales, and corresponding changes in Northern Ireland, which changed for those convicted terrorist offenders from automatic release at the halfway point of a sentence to referral in Northern Ireland to the parole commissioners after serving 2/3 of the sentence. So there are 2 changes. One, an extension of the minimum term before release is considered, and secondly, a change from automatic release to release on the recommendation of the parole board or parole commissioners in Northern Ireland. The relevant principles for Article 7 are set out at page 632, paragraph 78 onwards. At paragraph 78, the Supreme Court draws attention to the fact that the concept of a penalty in Article 7.1 is an autonomous convention concept, so it has an autonomous meaning within the convention. A corollary of that is that in assessing whether a measure is a penalty, and this is paragraph 79, the court is free to assess the reality of the situation. It's a question of whether in substance it amounts to a penalty, not the form of that. But jumping ahead to paragraphs 82 and 83, the court draws attention to the important qualification to that concept, which is that there is a distinction between a penalty and measures representing the execution or enforcement of a penalty, which don't fall within the scope of the autonomous concept. So for convention terms, there's a distinction there to be drawn. And it's recognised, paragraph 80, going back, that it's not always easy to draw that distinction. And then in paragraphs 85 of its judgment, 85 to 96 of its judgment, the Supreme Court went through some of the authorities. 85, considering the case of Hogben and the United Kingdom, in that case, the applicant was serving a sentence of life imprisonment. There was no minimum term because at this stage, minimum terms weren't set, although they could be recommended by the judge. If not, it was a question for the Secretary of State. There was a change to the parole processes then in place, with the effect that the applicant, who had been in an open prison on the understanding that he'd probably be there for 2 years progressing towards release, was transferred back to the closed estate to wait a longer period in prison, in his case 15 years, until he had served 15 years. And the European Court held, as set out in the quote that's cited at paragraph 85, that change didn't affect the penalty to which Mr. Hogben had been subject, because the penalty was the sentence of life imprisonment. It was clear that was the penalty, and the changes to the parole process related to the execution of that sentence as opposed to being the penalty itself, notwithstanding that the changes meant he spent longer in prison and in different conditions. At paragraph 86, the court goes on to recite the domestic authority of Utley, in which licence conditions were imposed following the end of sentence where that hadn't been the expectation at the time Mr. Utley was sentenced, and over leaf at page 634, your Lordships will see that again that was analysed as not being a change to penalty but to the arrangements which apply to early release. Moving ahead somewhat to 635, Kafkaris in Cyprus, another European Court authority. Again, a case concerning a life sentence, in that case in Cyprus, the provisions which were challenged were firstly whether the sentence was a life sentence per se, or whether that was in fact in practice a sentence of 20 years, and there was an issue found by the court in relation to that, because it was unclear in practice what sentence there was, but the court found that it was, as a matter of law, the penalty was a life sentence. And the second issue which was challenged, which was that remission for up to 5 years for good behaviour, so the automatic remission applied to the life sentence, or sentence of 20 years, which was then could be whittled down depending on the prisoner's conduct in custody, so a remission of up to 5 years. The removal of that remission did not amount to a measure, the imposition of a harsher penalty, because although the changes made the imprisonment harsher, it wasn't a heavier sentence than had been imposed by the trial court. As with Hogben, that was a sentence of life imprisonment. And it's reiterated, and the quote of paragraph 90 sets this out, that issues relating to release policies, the manner of their implementation and the reasoning behind them fell within the power of contracting states to determine their own criminal policy. And that's a principle which continues through then the other cases which are cited, which are Del Rio Prada and Kupinski, which set out at 94 and 96, and I might come back to those because the respondent places some reliance on them. But that's the key in terms of the legal framework, that there is this, it's an autonomous concept, and there is this distinction between penalty and measures relating to enforcement or execution, which brings to the second part of these submissions, which is how do you draw that distinction? This was considered by the Divisional Court in the case of Khan, which is at tab 12 of the authorities bundle. Page 457 starts. And again, in Khan, the measures which were being challenged were, as with Morgan, but the English and Welsh equivalents, changes from automatic release at the halfway point of sentence for terrorist offenders to consideration of early release by the parole board at 2/3 of the way through sentence. And Khan deals with this point from page 481 onwards. Well, in fact, before 481, it goes through the authorities which were also considered in Morgan, which it's referred to in your lordships too. It deals with the contention that in Del Rio Prada there had been, as it were, a walking back of that principle. On the facts of the case in Del Rio Prada, it was held that a change to early release procedures did amount to the penalty, because, as we'll see, Mr. Del Rio Prada had been sentenced to 3,000 years, up to, I think, more than 3,000 years in prison. But the policy of the Spanish courts was to impose then a separate sentence independently, which made that a maximum sentence of 30 years, to which automatic remissions applied. And the European Court held that those were accrued rights, and so any change to that, as there had been through the application of a new policy, did amount to reimposing a different sentence. But the question in Khan was whether that meant that there was now a caveat to the position that measures relating to the enforcement or execution of sentence might be taken to be penalty. And the answer of the Divisional Court is that the European Court had considered this in Aberdeen, which followed on from Del Rio Prada. And that is set out at the bottom of page 481, paragraph 103. And it cites there the decision of the European Court, I'm sure it's a Grand Chamber authority, that the starting point of the court's examination, as was reaffirmed in Del Rio Prada, that where a measure, the nature and purpose of a measure relate to a change in the regime for early release, this does not form part of the penalty within the meaning of Article 7. So that's the starting point. In Del Rio Prada, on the facts, the specific measures that are applied did change the penalty, but the starting point remains that if measures relate to a regime for early release, then it doesn't. And it goes on over leave that the court went on to underline that the changes had to be distinguished from changes made to the manner of execution, so that distinction remained intact. And the critical element, the court said in Aberdeen, was that the critical element in determining the applicability of Article 7 is whether the changes introduced had the effect of modifying or redefining the penalty itself. So you're looking for an actual change in the nature or scope of the penalty that's been imposed. And as made clear in Khan at page 105, the changes there were held not to amount to that. They were changes in the arrangements for early release only, and so didn't raise any issue under Article 7. Cases in which court has held that there has been a change in the nature and scope which the appellant relies on are Del Rio Prada and Kupinski in Ukraine. Del Rio Prada is in the authorities bundle at tab 9, and just briefly, the court perhaps doesn't need to turn to it, but it explains from page 387, paragraph 99, the European Court explained there what the features of that case were that led them to conclude that there had been a change in the penalty imposed. It said at page 387, at paragraph 99, that it clearly had been the practice of the Spanish courts to treat the maximum term of 30 years, to which the 3,000 years of consecutive sentences had been reduced down to, as being a new independent sentence. So that was itself imposed as the penalty to which remissions applied. And so the scope of Ms. Stelvio Prada's sentence was, notwithstanding that the individual sentences cumulative came to about 3,000 years, a sentence of 30 years imprisonment, which was subject to automatic reductions. It went on to explain at page 380, paragraph 3, no, sorry, page 387, and overleaf onto page 388 at para 100, that the way those were applied was to give was automatic, and so the applicant had every reason to think, quote, the applicant had every reason to believe that the penalty imposed was the 30-year maximum term, from which any remissions of sentence and work applied, which is of course different to this case where, or any case where someone's sentenced to DHMP, where there can be no expectation that there'd be any reduction in the minimum term. What there is a right to apply for review. And at paragraph 101, the court explained why it was distinguishing the treatment, the remissions in this case from Kafkaris, the Cyprus case, where the remission of 5 years for those serving life sentence, up to 5 years for those serving life sentences. And it said it was distinguishable because it wasn't a question of discretion. These reductions were automatically applied. There was no role for the judge in applying them. They were therefore accrued rights in effect, and that the effect therefore of the doctrine is called the Paro doctrine, which the Spanish courts have been applying, was that it would convert a 30-year sentence to which reductions had been applied already to a 30-year sentence without any reduction, because those reductions were instead applied against the individual sentences, and so there was realistically no prospect of it ever being reduced. And that amounted to a change in the nature of the sentence which had been imposed. And similarly in Kupinski, which is at tab 17, page 646, paragraph 1 sets out the nature of the complaint, which was that Kupinski had been sentenced in Hungary to a life sentence. Under the Hungarian system, life sentences are reducible in the sense that there's eligibility to apply for parole. But he'd then been transferred to Ukraine, and under the Ukrainian system, there is no prospect of applying for parole. There is no mechanism by which one can apply at any stage to reduce a life sentence. It is a sentence for life in a strict sense. And that's set out in the court's explanation of the background of the case through paragraph 6 onwards to paragraph 23, where it explains why the Ukrainian courts, following his transfer back to Ukraine, had rejected his applications for parole on the basis that it was not a concept that was recognised in Ukrainian law. Page 655, paragraph 40, considering his complaint first under Article 3, the European Court reaffirmed that it had already recognised in other cases that an irreducible life sentence, which is one where there's no prospect of applying for release on parole, is not compatible with Article 3. And so Mr. Kupinski's case will be considered against that backdrop. It's the conversion of a sentence where there is the possibility, at least, of a sentence being reduced, whether that possibility became good or not, to one where there was no prospect because Ukrainian law didn't recognise that, and in circumstances where the European Court has held that that amounts to an Article 3 violation. But that said, the court did in Kapinski reaffirm that there is a principal distinction between penalty and a measure relating to the enforcement or execution of penalty. That's at page 657, paragraph 47. And it goes on in paragraph 48 to note that in the context of prison context transfer cases, so cases similar to Kapinski where someone's been transferred between jurisdictions and that has resulted in a change, the court had held previously that even where parole conditions were more stringent, that in and of itself didn't transform amount to a measure which went to penalty. It was a measure relating to enforcement or execution. It was the specific change in Kapinski that you change from a sentence where you've got no possibility of applying for parole to one where you do, that affected the analysis here and meant that this was an issue which went to the scope of the actual penalty imposed, because reducible and irreducible life sentences, and the court says at paragraph 52, are different in their scope. So tying that together, the key issue in determining whether you're looking at the penalty or a measure relating to enforcement or execution is whether there is a change in the actual scope of the penalty. So in Del Rio Prada, where the appellant lost accrued rights and a new penalty in effect was imposed, then yes. In Kupinski, where you change from a life sentence where you might apply for parole to one where you don't have that prospect, then yes. But what the European Court doesn't say is that the loss of a prospect or even the likelihood of being released earlier amounts to the imposition of a heavier penalty. And you see that from Hogben and Kafkaris, where the likelihood was that they would be released sooner, but due to the changes, they had to serve long periods, and the European Court expressly says that the fact that you serve longer in prison doesn't affect that analysis in and of itself. So finally then, applying those principles to the effect of section 27A, the Secretary of State submits that the removal of the possibility of applying for review is part of a measure relating to the enforcement or execution of sentences within convention terms, and so an Article 7 issue doesn't arise. In this case, the respondent was sentenced to detention at His Majesty's pleasure with a minimum term of 15 years. It's an indeterminate sentence with the possibility of release at a certain point. He'll have to apply for the parole board for that, and it will rest with them. He remains, following the enactment of section 27A, sentenced to detention at His Majesty's pleasure with a minimum term of 15 years. It's still an indeterminate sentence with the possibility of release following a certain point at the parole board's, in the parole board's judgment. The question is about how the effect of section 27A is to be characterised. And the effect is that it removes the right to seek a review of when that point, the point of release, should be, and possibly that it will be brought forward, but that is conditional. It's contingent on the application for review being granted. It's also contingent on showing exceptional progress in custody. So there's no guarantee that you would receive any remission, as it were. What it doesn't do is give any possibility of a longer minimum term being imposed. That's not something which occurs under section 27A. The worst case for the respondent in this case, or others in his situation, is that if he has no right to apply for minimum term, a review of the minimum term, he serves the full minimum term which was imposed by the sentencing court, and then after that the parole board will consider the question of whether he should be released, as it does in other cases. There's no question, therefore, of a heavier penalty being imposed. What's lost is a contingent chance of reduction. The fact that it might mean that he can't apply for parole until a later date doesn't affect that analysis. and doesn't mean that it becomes it's a measure. The imposition of a heavier penalty in convention terms. You see that in the European Court's treatment of Hogman and the United Kingdom and Kakaris and Cyprus. They squarely say that the fact that the applicants in those cases served longer in prison than they would otherwise have done didn't mean that a more severe penalty had been imposed on them. Similarly, in Khan and Morgan domestically, although admittedly those are in the context of determinate sentences, so the whole of the determinate sentence is the sentence pronounced, whereas in this case the sentence pronounced is detention at His Majesty's pleasure. But the same principles apply. There's no actual change to the sentence, just the provisions which govern release from it. It's not analogous to the situation in Del Rio Prada or Kipinski, where there's been a change in the actual basis of the sentence. My Lady, my Lords, on that basis, the Secretary of State submits that there's no question in this case arising under Article 7 in terms of the imposition of a heavier penalty. Article 7, that's what Article 7 prohibits, not the loss of a reduction of a chance for the penalty to be reduced. And there's also no issue in respect of foreseeability and whether the claimant could have foreseen those changes, because if the measure is correctly categorised as a measure relating to the enforcement or execution of the penalty, then it falls out with the scope of the law governing the claimant's detention for convention terms. And one sees that in Morgan, paragraph 104, page 638 of the Authorities Bundle, where the Supreme Court said there are two propositions. That where a measure relates to the enforcement or execution of a penalty, it doesn't fall within the law for Article 7 purposes and so isn't subject to that requirement of foreseeability. If it relates to the penalty itself, then it does, and there's an issue as to whether the penalty was foreseeable, and that's the issue that arises in Kafkaris. My Lord, my Lords, my Lady, unless there's anything I can assist with.
No, thank you very much.
Thank you.
Thank you, Miss Sullivan. Yes, Mr. Fitzgerald.
Oh yes, we have the additional cases now. Necessary. My Lady and my Lord, just before starting, I will go to the speaking there, but can I, in the light of the point that was made by my Lord Justice Lewis, just highlight for the court, first of all, the point that is made at page 100 of the core bundle in the judgment at paragraph 52, which focuses the issue of why should two people both offend under 18 and who are both sentenced to detention during Her Majesty's pleasure, because of that, be treated differently because of the date of their sentence. And the court highlights that at page 100, paragraph 52, explaining about delays. The consequence of these factors, this is about two-thirds of the way down paragraph 52, is that one offender who committed an offence of murder when, for instance, they were just 17, might be sentenced when they were still 17, whereas another offender of the same age who committed a very similar offence might reach his 18th birthday before the date of sentence. The fact that the second offender was 18 at the date of sentence would be random and wholly unconnected with the offender's culpability. Differential treatment resulting from random events cannot be objectively justified. And my Lord Justice Lewis focused on the issue, that's to say, the differentiation that has to be justified is why should two people under the age of 18 when they offended, which is the relevant age for detention during Her Majesty's pleasure, going back to 1908, the age of offence has been the test, be treated differently simply because of the date of sentence. It is not a justifiable differentiation. And then if one looks at the various explanations put forward, one explanation, which I'll come to in the white paper, was we have to achieve equivalence between the adult murderer and the person and the HMP detainee sentenced after the age of 18. That's simply, as my lady pointed out, that's just not an equivalence that is either desirable or right. And the second one was about the process of maturation. But the relevant point on the process of maturation is that significant, on any view, this is admitted by all parties, on any view, significant maturation continues after you're 18. So whether or not the rate of maturation accelerates, and there's a dispute about that, significant maturation continues after 18, and that is undeniable. It's established by a whole series of cases based on neurological evidence. And then just if I can turn very briefly to summarise the point to the question of the effect on victims. If one looks at the white paper, it's quite clear that what the concern was repeated reviews, subsequent reviews, numerous reviews. The review system as it then was. It might be legitimate to say we will reduce reviews in order to prevent distress to victims, but to remove reviews altogether and therefore remove an essential part of the sentence, we say is plainly disproportionate. And you have the case of Cunliffe, which is referred to in the judgment. There is a question as to whether a victim impact statement is even appropriate in this exercise, because as my Lord Justice Lewis has observed, it's essentially focused on whether the progress is such as to justify a reduction of the sentence. So so the Cunliffe case says to that exercise, it's not clear that it would be relevant to have a victim impact statement. But in any event, it would be, in our respectful submission, wholly disproportionate to remove all reviews simply in order to avoid the fact that a single review, knowledge that review was taking place, might
It
cause.
would be discrimination to remove all reviews if nobody got them. Then it's not breach of Article 14.
My Lord, there'll be other quarrels, but yes, of Article, yes, no, my Lord, your Lordship's right, but as your Lordship put it, and as my Lord, why single out this subgroup based on the date of sentencing, which can be, as is exhibited by the paragraph, something which is random, or at least not anything to do with fault on the part of the offender. And we say it is arbitrary and it is discriminatory, and it isn't justifiable by any of the justifications put forward. But can I now take the call a little bit more slowly through my submissions with that background? I mean, we've set out the position in our reply and speaking note, and if I can take you just to page 1 of that, of course, this concerns the radical changes to the treatment of some child offenders subject to the unique sentence of indefinite detention during His Majesty's pleasure, as it now is. Now, for many years, there's been an established procedure for all detainees to seek a review of the minimum term provisionally fixed at the outset of the sentence. My Lord, Justice Lewis correctly indicated that really it's a review with a view to reduction. The sentence is reducible. That was because the sentence originally imposed and still enforced by its very nature carried with it both the promise of and the right to a review of the minimum term in the light of progress during the tariff period. And that flows from the rationale of the sentence as explained in the case of Smith. And my lady, my lords, the right of an HMP detainee to a review and the reason for it was explained in Lord Bingham's judgment in Smith, and the court has that judgment, and it's at tab 7 of the authorities. And if one goes to paragraphs 10 to 12, these are the key points which we respectfully submit emerge from the analysis there. Firstly, that, and this is at paragraph 10, continuing review was, one sees it's been an important, this is at the bottom of page 318, important and distinctive feature of the sentence of HMP detention. The detainee should be subject to continuing review so that the detainee may be released if and when it is judged appropriate to do so. And that's based on the analysis of the decisions and judgments in the case of Venables. And then secondly, it follows from that any minimum term fixed at the outset may only be provisional. One sees that from the no objection in principle to the fixing of a minimum term to be served may only be provisional. And also, my lady, it may be more appropriate now to say must be reducible, because of course one now has the tariff fixed by it must be reducible. Since the progress of the detainee in custody reported through continuing review may call for it to be varied downwards. It was the sentence introduced in 1908 was modelled on the sentence for criminal lunatics, which of its nature called for continuing review. It's been adapted and modified, but that central notion that there must be review of the continuing justification for detention is retained in the notion of the reducible tariff.
Is that the case? I mean, even Lord Bingham was careful to say that this sentence was before the Parliament Criminal Courts Act, and that was the one, and we've seen the Sentencing Act provisions, which material the same, which said that now there will be a minimum sentence, a minimum term fixed on seriousness.
Yes, but my lord, absolutely. But nonetheless, the capacity for variation downwards or reduction downwards was accepted to continue after the introduction of the statute for fixing of minimums. Indeed, there's a long history of which.
Where does it say that? Because I thought Lord Bingham went out of his way to say he wasn't saying that.
No, it's not said in this judgment. All I can say, my lord, is there have been a number of cases where the Secretary of State has conceded since the introduction of the measure of the section that the position is still the same.
But he or she, there've been different people, have had a policy of doing it, and it's quite interesting as to why. But I would need to see an authority that said, notwithstanding the changes in the Powers of the Criminal Court Sentencing Act 2000, and notwithstanding the fixing of the minimum term, there must also still be the prospect of review, because the detention at His Majesty's pleasure necessarily now, notwithstanding the statutory changes, still involve that. I'd need to see a great authority to that effect.
Yeah, well, my lord, can I just take you, because there's a reference to where it doesn't matter. Can I just show, my lord, you'll see at F. There was, however, on the facts a marked contrast between the Secretary of State's approach to the task and that which a judge would have adopted. No doubt that contrast coloured the majority's thinking and reinforced their opinion that protection of the property. But their decisive conclusions, summarised in paragraph 10.1 and 2, rested on the inherent nature of the sentence of HMP detention, not on the identity of the authority setting the minimum term. So the fact that it's done by a judge does not alter the fact.
Yes, that's not the point. The point is that Parliament has prescribed that henceforth there will be a fixing of a minimum term by reference to certain considerations. That's what arguably has changed.
Yes, but my lord.
Who, but how and why?
Yes,
Prescribed
well,
by Parliament.
my lord, the rationale in our respectful submission is that there has to the nature for continuing review continues even in respect of the tariff. As Secretary of State has accepted that, and indeed, well, my lord, you can see it's accepted in the statute itself, and so there is a continuity that is retained. My lady, my lords, the requirement to impose a sentence is based not on the age of the offender when sentenced, upon the age of the offender when the murder is committed. That is crucial on that point, and that's made at paragraph 12 at page 319H. So you can see thus the requirement to impose a sentence is based not on the age of the offender when sentenced, but on the age of the offender when the murder was committed. And it reflects the humane principle that an offender deemed by statute to be not fully mature when committing his crime should not be punished as if he were. And that really is the point about, to the extent that one of the justifications for the change was to achieve equivalence with adult offenders sentenced to custody for life for murder, that plainly offends that humane principle. As he grows into maturity, a more reliable judgment may be made, perhaps of what punishment he deserves, and certainly of what period of detention will best promote his rehabilitation. That justification, we respectfully submit, continues, though, as my lord has observed, the key issue is whether there's exceptional progress under the statute. But has there been exceptional progress that indicates that the punishment can be reduced, or that his rehabilitation will be better promoted. And then the point is made, it would in many cases subvert the object of this unique sentence, and it remains that unique sentence, if the duty of continuing review were held to terminate when the child or young person comes legally of age. And one sees that there is a reference lower down to a reduction in the sentence imposed by court being a well-recognised exercise of executive clemency. One sees that at paragraph 13. But can I just take the court also to the point about the anomaly, which you can see, the court can see at paragraph 15G. It is true that no continuing duty of review applies to other sentences imposed on young offenders, because other sentences do not have the special features of HMP detention. That is anomalous only if it is thought that they should have those features. There is nothing anomalous in according a monitoring role to the Secretary of State as described above, nor, in my opinion, is it anomalous to continue to treat a person who committed a crime as a child or young person differently from one who committed a crime as an adult. In referring to detention during Her Majesty's pleasure, the 1908 and 1933 Acts used a form of words first found in the Criminal Lunatics Act, a clear indication that those so sentenced were not regarded as fully responsible. A crime committed by a person who is insane or underage does not cease to be such because he later regains his sanity or becomes adult. Now, well, my lord, my lady, we really say that that is crucial because it indicates that it's really contrary to the very rationale of the sentence as it has endured from 1908 onwards to remove the possibility of reducing the tariff because it's contrary to the notion of continuing review, and that stems not from the date of sentence, as Lord Bingham says, but from the date of the offence. Of course, it may originally, my lords, have originated because it was a reason for not applying the death penalty. And the crucial reason starts in 1908, that if you're under 16, you got detention during Her Majesty's pleasure rather than the death penalty. So crucial to that, crucial to the sentence, is the issue: how old were you when you offended? Not how old were you when you were sentenced, but how old were you when you offended? And that's remained the crucial rationale and hallmark of the sentence. So if you retain the sentence, and Section 27A, and as my Lord has pointed out, Section 259, retain the sentence of detention during Her Majesty's pleasure, you retain a sentence which is defined and imposed by reference to the age of the offender when they commit their offence. And that is the crucial determinant of the sentence, that firstly, it's determined by how old you were when you offended, and secondly, that there is this duty of continuing review, much attenuated now, we accept, but at least reflected in the notion that there should be a reducible tariff. It's unique, but it is the distinctive feature. Now, the Secretary of State retains the sentence of detention during Her Majesty's.
The point is, when the sentence was first created, there was no way of knowing how long the child was ever going to be there, because there wasn't a judge fixing a tariff, there wasn't a minimum term. And gradually over time, a number of things have happened. One, we recognise that sentencing is a judicial act, not an executive act. And two, Parliament now has changed the operation of the sentence. It hasn't changed the name, but it's classified it as a life sentence for the purposes of the operation of the minimum term. So one wonders what role the Secretary of State has after that. That's what I was asking my friend. What's the Secretary of State doing here anymore?
Yes, well, my Lord, the sentence remains. I mean, my Lord, in the end, if one looks at the question of the comparisons, and this really comes back to my Lord's point, you've got two people, both of whom are offended under the age of 18. They're both subject to the same sentence. How can you justify treating them differently because of the date of sentence? And that's the crucial issue we come to in the end, irrespective, as it were, of. But it is significant that they are subject to the same sentence. Now, my learned friend, the reason why the court had to go into the question of whether the sentence had been changed was because my learned friend was saying that Section 27A11 amends or redefines the sentence. It doesn't do that. The sentence remains the sentence. It doesn't amend it or redefine it. And what the court said about there's no sign of Parliament intending to amend or redefine the sentence was solely responsive to that argument.
Well, I think they may have missed a trick in the sense that maybe the 2000 Act that redefined the operation of the sentence rather than 27A, but it doesn't matter.
Well, my Lord, as my Lord observed, in the end, the issue is: can you justify according the right of a review with a view to reduction to all those who offend under the age of 18, except those sentenced after the date? And the anomaly pointed out, the manifest discrimination. And the other question is there any rational relationship between the reduction of distress to victims and the fixing of the date as the date of sentence? All it possibly does is to mean that a limited number of people don't get reviews at all. But as against that, it's a massive change to their previous rights, and a massive change to their prospects of rehabilitation and reduction, all justified by reference to the fact that my learned friend ends up saying the victims, there'll be, I suppose, a minimal reduction of victim distress because they won't be informed, well, there is going to be a review, one review. It's completely disproportionate. And then it's justified by this bogus notion of no significant maturation. But in fact, there is significant maturation after 18. So, my lady, if I can then take you on to, you have the facts. I'm sorry that at 1.7 it gets it wrong. It should be halfway point of a sentence in March 2022. But the point is that in Mr. Quay's case, whether or not his sentence has been amended, the denial of review to him and those in a like position remains discriminatory, unjustifiable, disproportionate and arbitrary, because he is denied the review that his co-defendant will have solely on the basis of the fact that he was sentenced after attaining the age of 18, though they both were minors when they offended and though both were still subject to the same sentence. And we do make a retrospectivity point, but on any view, this involves a retrospective harshening, whether it's within Article 7 or not, a retrospective harshening of the treatment that will be meted out. Now, we submit that the Divisional Court rightly rejected the justifications put forward for that legislative change. Can I just, in the last 5 minutes, just deal with this point? On the Article 14 test, the test for Article 14, as my learned friend has said, is agreed. We agree between us that there's been differentiation of treatment on a ground within the prohibition in Article 14, that's to say age, and the Divisional Court records that at paragraph 32. The key issue, therefore, is whether the difference of treatment has an objective and reasonable justification. In other words, whether the Secretary of State has shown that there is a reasonable relationship of proportionality between the means employed and the aims sought to be realised. We just make one further point that the burden is on the Secretary of State to justify it, and that's reflected in SC at paragraph 53, page 538, but also in the Camp Cotton case, which we've handed up to the court. So the appellant argues that the test is whether the legislation is manifestly without reasonable foundation, and that was the test that the Divisional Court applied. That's at the bottom of 2.2, at paragraph 46, and they also applied a low level of scrutiny at paragraph 47, as contended for by the appellant. And yet, even on that test, the Divisional Court rightly held that the measures were not justified. So they said, even applying a low test, it's without reasonable foundation. But we do make the point that actually there were the most powerful reasons to adopt what the European Court in the case of Clift called an approach of anxious scrutiny, as it were, careful scrutiny or close scrutiny. We've set out the passages there in the middle of 2.2. My lady, perhaps would it be appropriate if I dealt with? So can I'll just deal then with why it's appropriate to apply careful scrutiny, and then to take the court through the white paper, which we're agreed is the test. And just summarising ahead, if you look at what we say at Roman 1 on the white paper at page 5, the concern was actually with continuing reviews. And the words continuing reviews, subsequent reviews were perpetually the words used to describe what caused the distress to the victims. Not a single review, but continuing reviews. And moreover, the proposed change was intended to equalise the position of those given life sentences for murder committed over the age of 18 with those who commit murder as children but who are not sentenced until they're over 18. You can't equalise those positions, and that's a totally arbitrary attempt at equalisation. As my lady put to my learned friend, what is the justification for treating an adult murderer sentenced to custody for life the same way as a juvenile subject to this particular sentence because of when he committed the offence. But I will go through each of the justifications, my lady, after the break, if I may.
Thank you very much. We'll sit again at 2 o'clock. Thank you.
What, rise the table?